Greetings, everyone. Once again, I would like to take this opportunity to thank you for your viewership, and I also want to thank you for your subscriptions. It's really an honor to talk to you once again. And today I want us to talk business. I've received a number of calls about disputes in business. People asking me how such disputes can be resolved. And it is important for me to address this subject in an illustrated manner. It's very important for me to address that kind of subject. So allow me to take you through commercial dispute resolution. We want to look at the different ways of resolving disputes, and I'm dwelling mostly on business transactions. Of course, it is not the will of contracting parties to face what we call disputes. Most people enter into what we call mutual understandings, where there is what we call a willingness of the parties. And because they are willing, they enter into a contract where the principles of offer, acceptance, and consideration apply, and of course capacity to contract. But you find that in the course of the said transactions, disputes may come about. Disputes may occur. So the question is, how do you resolve such business disputes? Allow me to take you through commercial dispute resolution, where I'm going to dwell on the different ways of resolving business disputes. Number one is litigation. Litigation. And litigation is the act or process of bringing or contesting a legal action in court. This is where one party to the contract or to the business, because of a dispute, he comes up with a complaint in court. And litigation is a judicial process of settling a dispute in courts of law. Settling a dispute in courts of law. It is settled through instituting a lawsuit in a court of law. You come up with what we call a lawsuit. And a lawsuit is basically a composition of what we call a plaint. And this is where the aggrieved party, the party whose rights have been infringed upon, he comes up with a detailed complaint, which in law we refer to as a complaint, or we refer to as a plaint. And he institutes that plaint in a court of law, against the party who has infringed on his right. So a question arises, where can one file a lawsuit? Now, when filing a suit, one needs to determine in which court to file the suit and in which area to file the suit. Because suits arise from different areas. It may be land, it may be out of a contract, a business contract, sale of goods contract, or any other form of transaction. So after getting to know where that suit originates from. It is also important for you to note the court in which you are going to file the suit. Is it going to be in the magistrate courts, or it is going to be in high court? And all that will depend on the value of the subject matter. It will depend on the value. If it is 49 million and below, that is a subject of the magistrate court. And if it is 50 million and below, it is a subject of the high court. Because it is the high court that has what we call unlimited jurisdiction. So, how are suits instituted? How are suits instituted? Now, in Uganda, suits are instituted in the manner that is prescribed by the civil procedure rules. And as a general rule, suits are instituted by filing a document called a plaint with court. The plaint primarily contains your case or claim against the other party you're suing. For example, the plaint will contain the reason why you are suing and the damages you are seeking from the defendant. That is the rough composition of a complaint or a plaint. So when it is taken to court and it is accordingly received, the defendant will be called upon to put in what we call his statement of defense. He's also supposed to be heard. His position is supposed to be heard. And because it is a civil action, the magistrate or judge will use his discretion after listening to both sides and come up with what we call a balance of probabilities. And then he will reward either party accordingly. That is what we mean by the litigation process in regards to a civil action. Now, briefly, let's look at the advantages of litigation. It settles disputes. Number two, it protects the rights of individuals. People are free to go to court in case their rights have been infringed upon by other people. It serves justice. And number four, it awards damages in case of any loss or injury. Now, there are also disadvantages to this system, the number of disadvantages. And number one is that it consumes a lot of time, takes a lot of time. Some cases may even take 10 years. It's susceptible to corruption of the lawyer, corruption of the clerks, corruption of magistrates and judges. But all in all, litigation is one way of resolving commercial disputes. But there are other ways of solving disputes without necessarily going to court. And those are what we call alternative dispute resolutions. There are alternative ways of solving disputes without necessarily going to court. So briefly, let's make mention of them. I'm just going to make mention of around 3 or 4. And the first one is arbitration. Arbitration as a way of solving disputes without necessarily going to court. The International Chamber of Commerce defines arbitration as a flexible and consensual process of resolving business disputes in a binding and enforceable manner. In a binding and enforceable manner. It's very important, very important, that arbitration as a means of dispute resolution is consensual and arises from an arbitration agreement. And this agreement is supposed to be between the two disputing parties. Arbitration involves a third party referred to as an arbitrator. And an arbitrator listens to both sides and comes up with what we call an arbitral award or decision. An arbitral award or decision. An arbitrator is got based on the choices of the two disputing parties. They agree on who to arbitrate the issue between them. Unlike in the court system, you do not have a choice on who handles your matter. But when we come to arbitration, parties are at liberty to pick who to arbitrate the matter between them. Our advantages of arbitration is that arbitration is flexible since parties can pick on who to arbitrate the matter between them. It is relatively cheaper and it is not time wasteful. It's not time wasteful. Number two, as a way of resolving disputes without necessarily going to court, we have what we call mediation. A mediation is another form of alternative dispute resolution that can be employed in commercial dispute resolution. It involves a neutral person called a mediator. The mediator helps the parties arrive at an amicable settlement. Amicable settlement. Meaning that the mediator listens to the sides of both parties and on a balance comes up with what we call a win-win situation. That is the beauty of mediation. In mediation, both parties walk out of the dispute happy because they all lose and win at the same time. Unlike in arbitration. In arbitration, the arbitral award may go to one party. But in mediation, it may be a win-win situation, which is definitely of benefit to the parties. Number three is negotiation. Negotiation. A negotiation is where parties attempt to arrive at an amicable settlement, but without the help of a third party. In negotiation, the parties reach out to each other. One party writes to the other party seeking for negotiation in a friendly manner. There is no need of a third party in negotiation. A knows what B did. So A reaches out to B in order for them to negotiate on how to resolve the said dispute. It is that cheap. It's not an expensive venture. There is no need of a third party. Parties reach out to each other and come up with a settled score. So that is negotiation. And lastly is conciliation. Conciliation is a mode of alternative dispute resolution which can be applied to resolve or to try and resolve a dispute arising out of a legal relationship. In this case, what we call a commercial relationship. Conciliation involves a third party called a conciliator. He comes in to see whether these two parties can have what we call a meeting of the minds in order to resolve this existing dispute in a conciliatory manner, that you can sit at a table and weigh out options. You began on the good note. Why the bad note? Can we sit and conciliate this dispute so that we arrive at an amicable resolve. Thank you very much.